Please,
Yes.
Lordship. Lordship, I'd like to note item number 10. Lordship, there is a legal problem in this case. Followed by a notification dated 1st of June. Lordship. The one of the serial number 2 and 30. Second page, Lordship. One of the some of the brevet respondents has been promoted to the post of vice principal. Now, Lordship, when the notice was issued on 30/11/2025, this report is passed in order that any promotion made during the pendency of the writ petition, it shall abide by the final order of this report. So, Manoj, it is necessary for me to bring on report the subsequent developments. I may be allowed to file an additional affidavit to bring it on report. Lordship.
Mr. Takamasa, the learned senior counsel appearing on behalf of the petitioner, submits that there has been certain promotions made during the pendency of the instant writ petition, and the petitioner would therefore like to file an additional affidavit bringing to the notice of the court the said aspect.
Lordship, I kindly 3 weeks time and there are outstage of station lines.
List this matter, can we have it on 25th of June?
It is here 14th June, Lordship. My clients are out.
14th?
14th of July. Lordship.
Okay. List this matter again on 14th of July 2026. In the meantime, the additional affidavit be filed.
Lordship.
To this. Yes.
Lordship, I think we will item 22.
Two.
22. Lordship, here, initially we have filed affidavit in opposition, Lordship, in the course of hearing, Lordship, amended the respondent number 6 has been indicated, Lordship, and to that effect, Lordship, I'm here to receive this one.
Who will respond number 6?
Respondent number 6, Commandant NAP.
So it should not come up for hearing.
No.
When was the respondent number 6 impleaded?
Last game.
And notice received when?
Last year in the month of September.
Are you appearing for respondent number 6?
No.
So when are you filing the affidavit?
Lordship, since I'm yet to instruction.
That cannot be. It's a old matter, 2021 matter. We can't help you.
Then a short date. maybe.
Short date.
No.
It is seen that the respondent number 6 was impleaded in the month of September 2025. Mr. B. Jimomi appears on behalf of the respondent number 6. He submits that the respondent number 6 would like to file an affidavit,
No.
taking into account that the writ petition is of the year 2021 and almost 5 years have passed by. This court grants a final opportunity to the respondent number 6 to bring on record the affidavit. Full stop. List this matter again on 14th of July 2026. The affidavit be filed on or before 13th of July 2026.
Sorry, verifying that I don't know four. So then we go let's see.
4. What is you want to file affidavit? It has been submitted by Mr. Yangavati, the learned CGSC, that the affidavit on behalf of the Union of India is ready and would be filed within 2 weeks. Oh, you have filed? Then
Take it for initiating.
now, today.
That's the date. Wait. Which one?
Have you filed reply?
No,
You don't want to file reply.
no. No.
It has been it is submitted by Mr. Gauhati, the learned counsel, learned CGSC, that he is not ready with the matter. Accordingly, list this matter again when next week on 15th of June.
Lordship, I may be allowed to make a motion of one motion item for tomorrow. My lord, this is the matter which your lordship has heard last week. And lordship has asked us to withdraw that petition and file afresh. Lordship, the petitioner here is aggrieved by the seniority list. Apart from any further promotion due to the remark excess in the seniority list. So we have filed it on Tuesday, however, it has not been listed, my lord. So
Okay.
if it can come up tomorrow, my lord. Yes.
Let me see also. I already mentioned item 6.
6.
Yes, please.
Okay.
If David is ready, all sent over today. So right, there are 3 weeks.
Mr. L.T. Santam, the learned additional advocate general, Nagaland, submits that the affidavit of the state is ready and would be filed within 3 weeks.
Yes, sir.
List this matter again on 25th of June 2026. In the meantime, the affidavit will be filed. The interim order passed earlier shall extend extended till the next date. We can have it later on 16th of July. 16th of July. Affidavit be filed on or before 14th of July. Interim order passed earlier shall continue till the next date.
Also, regulation. Item 11. I have instruction to break over for this time.
Is submitted by Mr. L.T. Santam, the learned additional advocate. Nagaland.
And for the petition, your lordship, on the previous occasion, time was sought by the learned additional advocate. This may be the last opportunity of the matter.
What is the matter about?
This is about inclusion of 1,161 Hindi teachers who have been appointed under the centrally sponsored schemes into the state cater. They are regular employees under the state government, but they are not equally treated. Their salaries are not given regularly, and they are not treated at par with the state cater employees.
No, these centrally sponsored, they are appointed under the centrally sponsored scheme.
Yeah, your lordship.
Now have they been brought within the state plan, the state?
Yes, that was the direction by the central government. There is a document to that effect on 23rd of March 2011. I can assist your lordship. May kindly have page number 212.
No. Just tell me what is it?
It clearly says at paragraph 4 that the responsibility of maintenance of Hindi language teachers and payment of their salary after the completion of the terminal year of the next planned period rests upon the state government. They will be required to discharge this responsibility out of their own resources in their budget, and there will be no liability on part of central government in this regard. So this matter was listed on 20th of February. The state government had accepted notice, and since then the matter has been pending. On the last occasion, on the last day, the state government had sought time of 4 weeks for instruction and filing of affidavit as well.
So are you saying that the petition, it is a case of normalization?
It is a case of absorption into the state category, Your Lordship.
Understood.
According to the
So it was in the plan sector. It was in the plan sector, obviously, because it
Yes.
is a centrally sponsored scheme.
Yes.
So that is for a particular period, must be
Yes.
for a 5-year period, 5-year
Yes.
plan.
Yes.
And pursuant to the 5-year plan, now the state has the right to acknowledge, receive, absorb them within the state cadre.
Yes.
So they will like to be brought within the ambit of the state plan.
Yes. Lordship.
Now that has not been done.
That is,
Okay. And you have been working from 2011 to
2002, yes,
2012.
2012. The advertisement was on 2012.
But at that point of time, the notification which was issued, or this must have been as per the 11th 5-year plan, 2011.
This plan financial assistance to government of Nagaland for appointment of 1,379 Hindi language teachers for the year 2010 to 2011 under the centrally sponsored scheme of financial assistance for appointment of language teacher.
So therefore, this was done then in
Yes.
2011.
Yes.
When did the government come up and say, the central government come up and say that we are no longer going to look into this, you make the payment? When?
2000, this was on 28th of March 2011.
But at that point of time, you were not there in the service,
No, I was not there in the service.
but you knew it, that it was under the state plan. It was still under the grant in aid. It is a grant in aid now.
Yes,
You are
yes,
getting
yes.
your salary as per the
Yes.
grant in aid.
Yes.
So they are giving you as a grant in aid.
But Your Lordship, on the 28th of March 2011, according to the office memorandum, and also we kindly see page number 422, where it has been declared by the state government that we are regular employees. 1161 teachers are regular employees who are the petitioners hearing. And they have not been treated at par with state catered employees. That is the case. They have not been absorbed as a state catered despite being regular employees, and they are not receiving regular salaries.
Now, the reason is because it is still under grant in aid. The state is giving the grant in aid to these teachers, and accordingly the salaries are dependent. It is not put in the books of in the accounts in terms with Article 204. That is the reason why this is happening. If it is a state plan, then they will charge it to the consolidated fund of the state.
Yes, sir.
Now, grant in aid is not done. Grant in aid is put it as another thing that this is an expenditure. Every year they have to put it. Whereas if you are in the state cadre, it will be there automatically charged to the consolidated fund of the state. Anyways, let them file the affidavit,
Yes.
because without the affidavit, it cannot be done as to why they have not carried out. In fact, this process is called the normalization in budgetary terms. Anyway, because if normalization is not been carried out, then it is a case comes within the ambit of regularization.
My lord, we have the limited resources and each being 1,100.
So therefore, the question is, Mr. Sanktam, when the question is, these are 5-year plans on which the central government puts them.
Yes, sir.
They create resources. So they issue certain implementation guidelines, wherein it says that you are required, the state has to pay from their own resources. The state on its volition may absorb or not.
Yes, sir.
The court has no power to look into it. But the court has a power to look into it if it is a case by which a person has been kept out there, and there is an illegality or arbitrariness in not normalization, then the court can very well pass an order for regularization by creation of supernumerary posts.
Yes.
That's the way.
We are creating a police family.
Huh?
So that we can.
Last.
So that I will-
No, Mr. Counsel, last. I give you in the month of July, but last. Mr. L.T. Santan, the Learned Counsel, appearing on behalf of the state of Nagaland, the Learned Additional Advocate General appearing on behalf of the state of Nagaland, submits that 4 weeks' time is required for the purpose of filing the affidavit on behalf of the state. Mr. Estas, the Learned Counsel appearing on behalf of the petitioner, strongly objects to the said prayer, taking into account that on the earlier occasion also the petitioner, the respondents have sought for time. So, He further submits that from the year 2012 onwards, the petitioners have not been paid their regular salaries, although the government of Nagaland duly acknowledges them to be regular government employees. So taking into account the above, this court fixes this matter again on 23rd of July 2026. In the meantime, a final opportunity is given to the state to bring on record its stand on or before 27/2026. It is observed that if no affidavit is being filed by the state, this court shall proceed with the disposal of the writ petition by applying the doctrine of non-traverse.
Ungrateful, but ungrateful.
You read my judgment, there is one judgment on this aspect.
Yes,
Recently I delivered.
yes.
What you are arguing out here now,
Yes,
you will get the insight there. There I have dealt with this very aspect.
I'm grateful.
What has happened out there in these cases was you have this FFDA. FFDA is the Fish Farmers Development Agency. This was a centrally sponsored scheme. It started sometime around 1975-76. At that point of time, posts were being created by the government of India as well as being retained by the state. It was continuing. In the year 2025, the government of Assam took a decision that we go for normalization of these posts. Normalization, that is why I said that normalization means bringing them within the fold of the state, which are planned posts to a non-planned post. Now, there were various directions being issued by the central government that we see we have created the infrastructure. It is your bounden duty now to keep this infrastructure and do look into it and also pay it from your regular source of income. However, the state of Assam did not do it. Continued, goes on, continuing. The state of Assam, whenever the representation is being made, the state of Assam said that no, nothing doing. You belong to we have formed the society. You belong to a society. How do we bring in? I held that the making of a society is at the instance of the state. That has nothing to do. That is your prerogative. But these are posts which have been created in the plan. And thereupon you have retained all this while. So the you are not normalizing is an arbitrary exercise. But taking into account that this court is exercising powers under Article 2 to 6, this court cannot direct how the state will administer its post. That is not my lookout. But if it is arbitrary, then obviously these persons should be regularized, because otherwise they have been working all this while. Now applying Dharam Singh, which is the recent judgment. Dharam Singh, I passed a direction that they should be regularized into supernumerary post, and thereupon giving it effect from 2007. That was the direction passed, because then the proposals were sought for by the government, but they were not done so. So from 2007. So they will get all the pensionary benefits, all these things from 2007 onwards, taking into account. And any person who have retired, they will also be taking into account their regularization from there by creation of supernumerary post. Have a look at it. Hey, you give him that judgment. You ask him. Okay?
I'm so grateful, Your Lordship.
Yes. You look into that. Because there you will get the idea of what you are trying to canvas. It's a very new concept. You see, normalization, this court can't do anything. What you are asking is a pure case of a normalization. But with a pure case of normalization, it's very difficult. Because whether the state wants to bring them within the category or not, the court cannot pass it on. Because the moment what happens, if these posts are being normalized and brought into the state plan, irrespective of you being there or not, these will be an extra expenditure upon the state. So therefore, normalization is conversion of a non-planned post to a state plan. So it is the post. Whereas regularization is conversion of an employee who is temporary or a casual to a permanent. So that is why we can pass an order to that extent, not. Okay.
I'm so grateful for this.
Mr. Worship,
Yes,
on the motion item number 14.
1-4.
The worship here of instruction to appear on behalf of respondent number 4. Respondent number 5.
The mic is too tall for you. Okay.
The worship is 2 weeks may be granted to file an abandoned amendment activity in opposition.
You're appearing for respond number?
No.
4. And you? 4 and 5. 5. The councils appearing on behalf of the respondent number 4 and 5 submits that 2 weeks' time may be granted to them for filing their affidavit in opposition. The council appearing on behalf of the state, on behalf of the petitioner, do not object. Considering the above, urgency, no urgency. List this matter again on 21st of July 2026. In the meantime, the affidavit on behalf of the respondent number 4 and 5, as well as the state, you have also not filed, as well as the state, be filed on or before 17th of July 2026. Interim order there? Is it there or not? Silo. Interim order, if it is there, it will be extended till the next.
Mr. Worship, I take the motion item number 9. We are able to file our affidavit in Islam. We like to extend it.
No objection? The council appearing on behalf of the petitioner submits how many weeks? 4 weeks? 2 weeks' time may be granted for filing the affidavit in reply. You don't seem to have any urgency? You have no urgency? List this matter again on 23rd of July 2026. In the meantime, the affidavit in reply be filed. Interim is there? There. Okay. 2 weeks. List this matter on 23rd of June 2026. In the meantime, the affidavit in reply be filed on or before 19th of June 2026. Interim order passed earlier shall continue till the next day.
For motion item number 1.
Yes, madam. What is your matter about?
This is a recovery
Recovery.
issues.
You're grade 4, grade 3. You're grade 3, grade 4, which one?
Yes. Breakthrough.
Grade 3. Where is the impugnal notice?
We did not issue any interim notices.
And what are they doing?
Yes, Lordship will kindly come to beach. Annexure F beach 24.
Yes.
This is the our global salary statement of in respect of Srimati Menla UDA under GHSS November with effect from 9/5/11 to 28 to 25. So this is the
How many petitioners?
only one.
Where is the petitioner name? Oh, Mengengla.
Yes,
From 2011 to 2019.
yes.
How much money you have got? 6 lakhs.
6,12,808 plus her MSCP has been withheld and when she inquired about it, they have stated that even our MSCP will go into recovery.
So as of now, have they been deducting from your salary?
No, not yet.
Not yet.
So I have told this will be still in service. She will be retiring on 31/1/33.
33.
Yes, coach.
What do you say, madam?
That's a motion. It's good to switch.
Hmm?
Let notice for.
Let notice, she's.
Notice?
But will notice or whatever change the proposition of the system.
Okay. Issue notice making it returnable on, we'll pass a stay. We'll have it on 17th of July. Okay? Issue notice making it returnable on 17th of July 2026. So and so accepts notice on behalf of respondent numbers 1 to 4. 1 to 4. Who is Accountant General, Mr. Mujoy
Yes,
or Mr. Seki? Mr. Mujoy is there.
I haven't served notice yet. We haven't served notice yet.
Now, where is Mr. Mujoy? Has he come to the court? Or Mr. Seki? Anybody junior of Mr. Seki? He's also there, na? Accountant General.
I remember only Mr. Mujri,
No, he also appears, no?
maybe in election.
No, why should we issue notice? If he can accept notice, the matter is over. Unnecessary you taking steps by speed post. Because I'm passing a stay order. So if I'm passing a stay order, I'll make it sure to that effect. Today I have got a lot of time taking into account most of the matters Mr. Sankam has taken adjournment. So and so, Namtudidi accepts notice on behalf of the respondent number 4. Extra copies of the petition be served upon them, the learned councils, by tomorrow. The petitioner herein, who is working as an upper division assistant, which is a grade 3 post, huh? Is aggrieved by the recovery, is aggrieved by the proposed actions to recover an amount of rupees 6,12,808 from the salary of the petitioner. In respect to certain excess payment, alleged excess payment made to the petitioner during the period from 31/9/2011 till 28/2/2025. Ms. Jimomi, the learned counsel appearing on behalf of the petitioner, had submitted that taking into account that the petitioner had no role in the fixation of the pay, and further to that the petitioner is a grade 3 employee, the respondent authorities cannot be, it would be inequitable on the part of the respondent authorities to make such recovery. And in that regard, referred to the judgment of the Supreme Court in the case of Rafiq Maksi, whitewasher versus State of Punjab, reported in so and so. This court have duly perused the materials and record. And in the opinion of this court, that unless the petitioner had a hand in the, it is the prima facie opinion of this court that unless the petitioner had a hand in the fixation of her salary, which led to the excess payment, the case of the petitioner squarely falls within the ambit of the judgment of the Supreme Court in the case of Rafiq Masi, Supra. Considering the above, this court is of the opinion that the petitioner has been able to make out the case for passing certain interim directions. Accordingly, this court directs that till the next date, there shall be no recovery made from the salary of the petitioner on account of excess payment being made to the petitioner. Full stop. The respondents herein are further directed to bring on record their stand by filing the affidavits on or before 14th of July 2026. The reason being that as this court had passed an interim direction, and if the respondents delay in filing the affidavit, it would delay the further disposal of the instant proceedings. It is observed that if the respondents do not file their affidavit, they do so at their own peril.
For motion, item number 2.
Same.
Say, yeah, the designation is, the petitioner is language teacher. Yeah, in this matter.
Language teacher, how will he come? He is not grade 3. So it was grade 3 Gusaidi, language teacher, and no role in fixing the excess salary. But I think here you have a problem. Language teacher, then if it is 2025, they can very well do it. And when are you retiring? When are you retiring?
Not now, 36/30. From 36/2030. The amount also differs, Lordship, here is 2,08,309 in this petition, as well as our MACP was being withheld. MACP already prepared this bill, the first, in the first petition as well as here. But they are saying that it will go towards recovery of the, along with the salary.
Now we can stay only till 2021. 2021, 5 years permissible as per Rafiq Masi. 21, earlier it is, all this amount which is there. From 22 onwards, any payment out there, these can be recovered, but that will be subject to the outcome of the petition. So and so submits that submits the Rafiq Masi and all, but she says is there excess payment being made, so and so believable. Don't put grade 3. Huh? This court have duly taken note of the judgment of the Supreme Court in the case of Rafiq Masi, wherein the circumstances under which it was held to be inequitable for making any recovery. In the instant case, it is seen the period for which the entire recovery has been sought to be done is from 1/2011 to 31/12/2023. First, taking into account the judgment of the case in Rafiq Masi, it is the prima facie opinion of this court that recovery so sought to be made up till 31/12/2021 it would be inequitable. However, for the period from 1/1/2022 to 31/12/2023, the same would depend upon the respondent, depend upon the response of depend upon as to whether the petitioner had any role in respect to, however, in respect to the period with effect from 1/1/2022 till 31/12/2023, this court prima facie is of the opinion that the same would not fall within the exceptions culled out by the Supreme Court in the case of Rafiq Masih. It is also the opinion of this court that this aspect needs to be adjudicated upon. Consequently, this court therefore passes an interim direction that there shall be no recovery of the amount paid allegedly in excess with effect from 1/1/2011 to 31/12/2021. However, in respect to the period from 1/1/2022 to 31/12/2023, the respondents may carry out any recovery. However, the same shall be subject to the outcome of the writ petition. Then remaining affidavit.
For motion, item number 3.
It would teacher day, language teacher,
This is graduate teacher, Lordship.
a graduate teacher, same order.
Here, the petitioner is going to retire on 31/8/2026.
Huh?
31/8/2026. She's going to retire. That means that it will be recovered.
So
for
here,
petitioner
no, for till
8,
31/2026.
yes, in August.
Okay. 31/12/2021, like no recovery. Remaining from 1/1/2022 to 31. Why are they still paying after finding out that this is up till 31/3/2026 also. See the fine, madam? They have come to know this is how you do. Okay, there is no stay as regards any AK type from 1/1/2022 to 31/3/2026. No stay, subject to outcome.
For admission, item number 5.
Huh?
Respondent number 1 Union of India is ready to file the reply.
Won't go as per what they respondent filed. What is your case?
2 and 3 have filed the reply. My lord.
What is your case?
We are seeking some time to file each number, my lord. Everything is done better before petition number 1 is the company situated in Mumbai. It is in transit, my lord. In 1 week, the rejoinder will be filed.
When did they file the affidavit?
On the last date, my lord, 11/5.
Who has issued the recovery notice?
EPF is number 2.
Then the respondent number 2 is filed. That is enough. Why we inquire? And they filed the affidavit on 35. 35.
Motion actually filed on 11/05/2025, but there was some error in our petition, so our petition was rejected.
Okay, it has been shown as filed on 35. I have to give them some time. It has been submitted that an affidavit in opposition has been filed by the respondent number 2 and 3 on 35/2026. And as such, the counsel appearing on behalf of the petitioner seeks for an accommodation to file a reply. This matter again on 22nd of June 2026. In the meantime, the reply be filed on or before 18th of June 2026. Interim order passed earlier shall continue till then.
My lord, can it be on 25th of June?
We can fix it next year also, but no interim order to be extended, okay?
My lord, whatever date,
I'll
27th.
pass it.
So, interim to continue.
I passed it till the next date.
For admission, item number 7.
Office noted. I will work on the petitioner hearing this spring for the realization of the case of issues.
You completed how many years?
24 years of service. 24 years.
But was there any vacancy? Yes, madam.
Worship, the petitioner has done only 24 years. So this for the.
17.3 does not come in. So therefore, the only thing is 16.9, isn't it? 16.9 is dependent on vacancy. What?
Your Lordship, I'm claiming for regularization on the principle of law. Lordship.
On behalf of, on the basis of?
On the principle of law, laid down by the, honorable effects law and.
We cannot give that. In Nagaland, we can't give that because they have a policy. If they have a policy out there, how do we do it? They have a policy, yes. If there is a vacancy out there, we are doing it. If there is no vacancy, we can't give it. Can't have it. Because otherwise, if we give this, the entire framework of their regularization policy will become unless you show, unless madam, if you show that there is a person who was junior to you who have been regularized. Can you show that? Unless you don't show that, that is a very difficult proposition, madam.
In this case, can you get one week stand?
22.9. You have, there has to be vacancy.
So after the petition is solved for you.
Huh?
As for purpose of the in 11, actually, the petitioner has solved another time.
Okay. Where is your senior? The senior has just thrown you. Huh?
It's possible.
Where is your senior, Mr. Wati Jamil?
It's out of station.
We are not ready to go. You bad case. And you retired on 15/12/2022.
Yes, you know.
Then, at that point of time, if you don't come within the ambit of those office memorandums, very difficult. Because if we give any order out here, that will be wrong. You may have judgments like Dharam Singh and all these things, but that cannot be because Dharam Singh has looked into in another aspect. Unless you come up with that. Anyways, why should I dismiss? Let her senior, if her senior had come, I would have dismissed. Ms. So-and-so accepts the learned counsel appearing on behalf of the petitioner seeks for an accommodation. Gusto. This court, Ms. So-and-so, who appears on behalf of the respondent, on the other hand, submits that the petitioner has no case, inasmuch as the petitioner had retired in the year 2022. The petitioner had only completed 24 years of service and as such could not come within the ambit of the office memorandum dated 17/3/2015. Further to that, at the time when the petitioner was in service, the petitioner did not qualify in terms with the office memorandum dated 22/9/2004. First, The learned counsel for the respondent further submitted that if any directions for regularization is passed in the instant case, the schemes of regularization which the government of Nagaland is following would be rendered ineffective. However, the learned counsel appearing on behalf of the petitioner submits that she is handicapped without the presence of a senior. Considering the above, this court as a final opportunity grants an adjournment and directs the matter to be listed on 15th of June 2026. The petitioner shall have to argue the matter. The petitioner shall not be granted any further adjournments. Okay. So I made the groundwork for you.
For admission, item number 8.
My lord. My lord,
Mr. Khera,
my lord,
matter which
my
I
lord.
earlier passed an order whereby there was
On 26th of March, my lord.
Keep on now. Yeah, that is the order.
My lord, we have filed an affidavit today. In continuance of my lord's order, we have filed an application before the Deputy Commissioner requesting assistance in providing us assistance under 16(1) to enable us to shift the tower and realign the route, my lord.
What has the Deputy Commissioner done?
My lord, in continuance to that application is still pending before the Deputy Commissioner, my lord. 2 rounds of meetings have been held. The minutes of the meeting also I have brought on record by way of an affidavit filed today itself, my lord.
I also with this location. The Gauhati Corporation is misleading this honorable court. If I will be allowed to read my Iraqi government within a position. I will be allowed to read my within a petition when it is free.
There are 5.
In my laptop.
Yeah, read my law.
Yes.
That with regard to the statements made in paragraph 7 of the petition, that whether that is made by a complaint letter reference letter number such and such, then second May 2023 was received from the General Manager Party Bogosun Nagaland, stating that the landowner of the stone quarry near the Tower location 152 or 220 kV double circuit Merali Mogocho transmission line in CDC area are excavating excessive soil at the bottommost level to remove the rock/stone for the livelihood of the petitioner, where the tower location 152 is becoming critical. And
Mr. Sankam, I know this. No. See, no, Mr. Sankam, kindly listen. I know this aspect. Here the case is, she is the owner of the land nearby to the post.
Yes, sir.
Now, in this particular post, on account of a complaint being made by the power grid,
Yes, sir.
you passed an order stopping the further excavation by the petitioner.
On the complaint letter,
Understood.
sir,
Thereupon, there is a challenge being made by them that how can they do so? Either you acquire my land or you do something.
yes, yes,
The Power Grid Corporation, on the last occasion when the matter was taken up by me, first date, when in the month, first time I took it up, they say that they are going to file an affidavit as to what is the status.
yes,
Then they file an affidavit. When the second time I took up the matter, Power Grid said that we are taking steps. We don't want to acquire the land of the petitioner. What we want to do is we are looking for an alternative location for shifting of that particular pillar.
150.
Huh?
Pillar, 150.
Whatever it may be, to shift that pillar. Now, in pursuance to that, I have asked them to take it up with the Deputy Commissioner in exercise of the powers under Rules Section 16 or the Telegraph Act. That is what Mr. Khera is submitting, that they have been talking it up with the District Commissioner for allotment of any land, because the District Commissioner has the power to acquire. Isn't it, Mr. Khera?
My lord, but my lord, here the acquisition won't happen. We'll only get the right of way.
Huh?
There will not be any acquisition of land, my lord. We will only get the right of way under 10B and 10D, my lord. We don't acquire property,
No, Mr. Counsel.
my lord.
The right of way is for the tower, for the line.
My lord,
Line. I'm not on the last transmission line. But where
my
you
lord,
have the tower,
my lord,
there
my lord,
you have to acquire that portion of the land.
Yes.
There's no
my
there.
lord, we don't acquire that land, with all due respect, my lord. 2017 guidelines. I'm only referring to the Assam guidelines now, my lord. Nagaland has also adopted the same. We will only pay certain amount within the tower base area, 85%.
No, that
And we don't,
right of way, Mr. Counsel. But where you are going to insert, if you don't, okay, you go ahead. We vacate the interim order.
my lord, I was only trying to bring the factual
no,
position of
vacate it.
law on it, my
No,
lord.
no.
We never attain the ownership of a property.
No, you have to take over that land wherein you are going to install the tower. As
My
it-
lord,
the transmission line, it will be the right of way.
my lord, my lord.
There's no quarrel with that proposition, because how can you be allowed to install something in somebody's land without an acquisition of that part? It may be a small area. It may not be a huge area for that. Therefore,
My
right
lord,
away you pay less. But as regards the transmission tower where you are going to put it, that is absolutely there.
my lord, there are guidelines to that effect, and we follow those guidelines, my lord.
Then you are
My
not
lord is right.
that can be sure we are concerned with the tower being shifted. Whether you pay the right of way to whom, we are not bothered to that. If you take it
My
over
lord,
the land, you have to pay the petitioner whatever may be the right of way. Obviously, between
my
the
lord,
towers, wherever the transmission line goes, there might be many aspects that it might be have a high tension wire, and because of the high tension wire, the entire area may become useless. These are things which will be looked into under Section 16, 10 and
my
16.
lord,
I have nothing to do on that. But
my
my
lord.
out here is these for the purpose of the tower, what has happened?
My lord, for this we had written a letter after my lord's direction, my lord. And
Where?
that letter has, my lord, we have filed it on the strength of an affidavit today.
Where?
If just I'll request my colleague there to give a copy of the letter to the court,
Where is your colleague?
my lord.
What letter did you write? Did you write a letter for acquisition of some land or for right of way?
My lord, we wrote a letter under 16(1) for removal of obstruction and facilitation of transmission line work, direct stringing between tower location 151 to 153.
Understood. Whatever may be, they have to, you have to acquire if some land is triggered. But if you want to, otherwise, but we cannot stop them from excavating. They have a right.
My lord,
You withdraw
my
that.
lord,
Well,
You withdraw that letter. Matter.
I am trying to say is that as many as
You withdraw
6
that
times
letter.
the
my lord, this being said, my lord, we are also in the verge of doing certain more technical surveys and observation, my lord. So, my lord, I think, my lord, if 3 weeks is given, maybe we can come up with something conclusive on it. So that even the petitioner is not hampered, my lord, and the transmission system is also not
Withdraw the
hampered.
restraining order. Mr. Langtham. Mr. Sangtham, you withdraw the restraining order, matter over.
lecture A my lord.
My lord, page 66 is the order, my lord. Annexure 6.
Another person who is asking for compensation is of demand for who is Mr. Kumsang Toba? You are?
Yes, the petitioner.
No. Petitioner name is different. Yes. Regarding, it was informed by the Deputy Commissioner, Deputy General Manager that the said notice has been forwarded to the legal branch for examination and timeline and compensation for land acquisition. It is further resolved that district owner shall negotiate with the landowner to determine a suitable rate as per the DLCB rate for compensation of the land proposed for the construction of the tower. Upon securing the rate accepted by all parties, the same shall be communicated to the power grid for further insight. Then what happened? This was on 22/5. What happened? What is the new development, Mr. Counsel?
Very conveniently, the next only the last first June 2026 minutes of the meeting. My lord, as many as 6 times, the Deputy Commissioner had convened the meeting along with the Power Grid Corporation, but they are trying to shift from one end to another. Instead of negotiating, the Deputy Commissioner office is trying to explore whether or not to purchase the land or pay the compensation, but they are not coming forward.
My lord, the last minutes of the meeting is at page 18, annexure 3 of my affidavit today. The latest, that is on 1st of June 2026.
Okay.
My lord, I placed the latest development.
We do one thing. Wait, I know this, what is to be done. Yeah. Heard Miss So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. L.T. Sangtam, the learned additional advocate general, Nagaland, who appears for response numbers 1 to 5, and Mr. N. Khera, the learned counsel, appears on behalf of the response number 6 to 7. This court, by an order dated 26/3/2026, categorically observed that without the respondent number 6 and 7 taking effective steps for either acquisitioning the land of the petitioner or shifting the tower, this court this court, by an order, categorically observed that the order impugned in the instant proceedings was prima facie without authority and jurisdiction. This court was inclined to interfere with the impugned order when Mr. N. Khera, the learned counsel appearing on behalf of the respondent number 6 and 7, submitted that steps are being taken for shifting the tower, and it is under such circumstances this court did not interfere with the order dated 18/5/2023. This court further directed the respondent number 6 and 7 in the meantime to take effective steps with the Deputy Commissioner Mokukchong and other authorities so the tower in question can be shifted, or in the alternative may initiate action under the Indian Telegraph Act 1885 for acquisition of the right of way of the land of the petitioner. Full. It has been submitted by Mr. N. Khera, the learned counsel appearing on behalf of the respondent number 6 and 7, that they have been meetings with the Deputy Commissioner Mokokchong on 2 occasions in that regard. Mr. L.T. Santam, the learned additional advocate general, Nagaland, however, submits that there has been no effective steps taken in that regard. It is the opinion of this court that if the respondent number 6 and 7 do not intend to take any effective steps, either for shifting of the tower or for initiation of proceedings under the Indian Telegraph Act, the respondent authorities cannot continue with the order dated 18/5/2023, inasmuch as the right of the petitioner as regards enjoyment of their land have been curtailed, which is a right under Article 300A of the Constitution. Mr. Nkera, the learned counsel appearing on behalf of the respondent number 6 and 7, submits a final opportunity may be granted to the respondent number 6 and 7 to take up the matter earnestly with the Deputy Commissioner Mokokchung. Taking into account the above, list this matter again on 25th of June 2026 for an update. Okay.
Highly obliged, my lord.
Mr. Khera, next time no more, huh? If I get the matter, your tower.
My lord, we are trying earnestly. We are just stuck in a catch-22 situation over here, my lord.
Catch 22. I understand. The
My
thing is,
lord.
you don't intend to make any payment. Why you are not initiating? Do something, make some little payment, let them go under section 16 before the authority, do whatever may be, but go ahead. There
My
is
lord,
no
I'll personally.
that. You say that you see the amount which you be given to them for the land would be an offer.
My lord.
So whether they are entitled for more money, the court may very well look into it.
My lord, 16.3 is open to them in that case. 16.3 is open to them.
Yes, it's always open to them. Okay.
My lord, I'll personally look into it, my lord.
Please.
I highly obliged.
For admission, item number 12.
Ah. Oh, withdrawn. Very good. Language. Whereas by the order it is appointed for temporary spaces on so and so was to be permanent on expiry of the various this begin with it on that and has been in a short and for the
It has been paid evidently and wrongly recorded, Lordship. No, Lordship, it is a targeted attack, Lordship. If the Lordship can see the orders which culminated in this notice, Lordship, which I think you also. Lordship, kindly come to the Lordship.
Madam,
Yes, Lordship.
we close this petition, this giving liberty for you to come. Now see a recent judgment of the Supreme Court. In fact, forget about that. Recently, one of my brother judges passed an order. I think it's a case of, Justice Rajesh Mojumdar passed an order. Similar things. What has happened is when I took up the matter, I said that you could not have terminated him. You asked Miss Z. Zimomi, her case. I've said that you could not have done it because what they did was they appointed the inquiry officer before even submission of the written statement. Meaning it was preconceived. And as such, I was about to interfere. They said, okay, they will withdraw it. They withdrew it. After withdrawing it, then the next thing which came in is they again initiated another proceeding. Matter came up before me. I granted a stay. You could not do that. The matter came up and I think Brother Rajesh, Justice Mojumdar had passed a judgment that the reason which was there to terminate at that point of time should continue at this also. If it is not there, it cannot, you cannot. There has to be good reasons for that. Whether only you are being taken or there are other employees who are also there. Who is terminated? As of now, your cause of action is no longer there. They've withdrawn it. So I give you the liberty to come back.
So, Lordship, then all the other impugn orders may also be confirmed.
Which impugn? But there's only one impugn order.
Not one, Lordship. All the orders which come over in this order is also the impugn order.
Which order?
Page 55.
Page
55.
55, yes. But this has nothing to do.
The same thing was. After the delivery of appeal orders. Because of the letter of the PNR, the DC has passed the appeal also. And they are at page 59 also. Page 59 also.
Okay, then
Page 61 also. Page 61.
it's okay. This led to the final order. The final order having been withdrawn, the other goes. Now, if they initiate an action, you come back. Don't worry. I'll record that aspect, no?
Lordship, but clear is that to take any steps as per the rules. Also,
Yes.
everything has to be
No.
good to us.
That I'm making it. Heard Miss So-and-so, the learned counsel appearing on behalf of the petitioner, Miss V. Sukroy, the learned additional AG, Nagaland, who appears on behalf of the respondents. It is the case of the petitioner herein that the petitioner was initially appointed as a sweeper in the office of the Extra Assistant Commissioner Naka under the establishment of the Additional Deputy Commissioner Nagaland by an order dated 8/8/2012. The petitioner thereupon have been discharging her duties. The petitioner further claims that thereupon the petitioner has been discharging their duties with sincerity and dedication. Pursuant thereto, the petitioner filed a writ petition claiming that she should be granted the minimum pay scale in the scale pay allowed to a sweeper along with arrears from the date of filing of the writ petition. The said writ petition was registered and numbered as WPC number 228-K/2019. The said writ petition was disposed of by the judgment and order dated 14/6/2022, thereby granting the relief to the petitioner that the petitioner would be entitled to the minimum scale of pay in the scale of pay allowed to a sweeper along with arrears from the date of filing of the writ petition. An appeal thereagainst was filed by the state, which was registered and numbered as Writ Appeal number 25/2022. The said appeal, the learned division bench of this court, by the detailed judgment and order dated 21/2023, held that the petitioner was entitled to the relief as was sought for in the writ petition and which was granted by the order dated 14/6/2022, passed in WPC number 228-K/2019, and thereby directed the respondent authorities to comply with the said order within a period of 60 days from the date of passing of the judgment and order dated 21/2023. The state respondents thereupon preferred an appeal before the Supreme Court, which was registered and numbered as SLP Civil Diary number 25185/2023. By an order dated 11/12/2023, the Supreme Court directed the state respondents to implement the order of the learned single judge of this court dated 14/6/2022. Subsequently, the special petition was disposed of on 22/2024 with an observations that as the order passed by the High Court have been complied with, and in addition, as per the affidavit of the Chief Secretary of the State, which was taken on record, the government is taking its own policy decision. The special writ petition was disposed of. First, it is the further case of the petitioner that in pursuance thereto, the respondent authorities have taken a vindictive attitude towards the petitioner and as such have issued the impugned office notice dated 31/3/2025, whereby the services of the petitioner was terminated on expiry of 1 month from the date of the issuance of the said notice. The learned counsel appearing on behalf of the petitioner had submitted that this very aspect of the matter is very much apparent from the impugned notice of termination. She further submits that against no other employee such steps have been taken. Be it as it may, it is relevant to take note of that when the writ petition was listed before this court on 27/4/2026, the learned coordinate bench of this court by an order dated 27/4/2026 by an order dated 27/4/2026, while issuing notice, stayed the impugned notice of termination dated 31/3/2026. The writ petition thereupon was listed on 26/5/2026, wherein the learned Additional Advocate General Nagaland submitted that the reference so made to the judgment dated 14 to the writ petition dated 228K/2019 in the impugned notice of termination may not have been proper. However, she submitted that she would obtain instructions in that regard. The records further revealed that the matter came up before this court on 29/5/2026, wherein the learned Additional Advocate General further submitted that the respondent authorities were contemplating of withdrawing the notice of termination dated 31/3/2026. Today, when the matter is being listed, Ms. V. Sikroy, the learned Additional Advocate General, submitted that by the order dated 1st of June 2026, the notice of termination dated 31/3/2026 have been removed with immediate effect. A copy of the said notice of termination have been provided to this court, which is kept on record and marked with the letter X. The court finds it very pertinent to reproduce the notice of the order dated 1st of June 2026 issued by the Deputy Commissioner Nagaland. The same is reproduced hereunder this X. From the above, it is therefore seen that the very cause of action for filing the instant writ petition no longer survives, inasmuch as the challenge to the said notification office memorandum, the notice of termination dated 31/3/2025. 31/3, na? The 26. 31/3/2026 have been revoked by the order dated 1/6/2026. Accordingly, this court therefore closes the instant writ petition. First, it is before parting with the record, this court further observes that the closure of the instant writ petition shall not preclude or prejudice the petitioner to again approach this court if any action is being taken by the respondent authorities. And similarly, the instant order shall not prejudice the respondents to take any action against the petitioner if it is otherwise permissible under law. Okay? I gave you everything, both of you.
Item number 13.
Yes, Mr. Jamil, your matter.
Yes, Lordship. Lordship, I have received a letter that the draft received from the PC, so it can be wrong place.
My client is completion.
Huh?
My claims of completion, it has been disposed. So the petition has become infructuous.
So the final seniority list has come in. The final seniority list has been, the tentative was made final.
Yes, adding back to question. I have submitted question of question, but I've been to reliable source and informed that before disclosing my plans and application steps have been taken to make further submission based on the candidates. So I'm approached the board, seeking for direction for the further question of application, and this duty is cross approved, whatever respondent to dispose of to my plans and application before acting on the certificates and activities.
So they've done it.
Yes.
No, Mr. Jamil, have you given a copy to Madam?
Yes.
You kindly see this, the second page of that minutes.
Well,
During the course of deliberation, the Deputy Commissioner sought clarifications from the claimants regarding the absence of any challenge to 2009 promotion order for nearly 17 years. The claimant could not produce any documentary evidence to establish that they have raised objections at the relevant point of time. The meeting observed that the service matters relating to promotion and are required to be challenged within a reasonable time, and that claim raised after an extraordinary delay without supporting documents cannot ordinarily be entertained. After careful consideration of the submissions made by all concerned and examination of their available records, the meeting noted that so-and-so and so-and-so and so-and-so were promoted to the post of grade 1 so-and-so and so-and-so respectively through due process. The meeting further noted that the promotion granted to so-and-so in 19 had remained unchallenged for approximately 17 years and consequently attained finality. Now you see the last line. Accordingly, the meeting unanimously resolved that no further grounds exist to alter or revise the existing incumbency position and the seniority status of the Dobasi as reflected in the seniority list published on so-and-so. So,
so this will be.
your tentative has become final.
Fresh cause of action.
It will be a fresh cause of action you need to challenge.
So why is this petition was found also regarding to page 11, my prayer.
Now, I've seen it, I understand. Now, your thing is that you have submitted a representation that has not been constituted pursuant to the tentative seniority list being here. But it seems now that they have made that tentative final.
Final. So this will be.
So it also seems that because of my order passed, it had given a push. Because this was done on 3rd, I passed the order on 1st. I've heard Mr. T.B. Jamid, the learned counsel, appearing on behalf of the petitioners, Ms. So-and-so, who appears on behalf of the respondent state, and Mr. A. Sufi, who appears on behalf of the so-and-so. The instant petition was filed on the ground that the representations so submitted by the petitioner, claims and objections which were submitted by the petitioner as regards the tentative seniority list of the Dobashish, grade 1.
The ministry staff, the bushes and others.
No, you are also a Dobashi.
And
So it is only quarter Dobashi. In respect to the Dobashis, was filed on account of the claims and objections so submitted by the petitioner as regards the tentative seniority list of the Dobashis were not being considered. This court duly takes note of the instructions placed by Ms. So-and-so, the learned government advocate, dated 3rd of June 2026, issued by the Deputy Commissioner Khifri, Nagaland, which is kept on record and marked with the letter X. To the said instructions which is kept on record and marked with the letter X, the minutes of the meeting held on 3rd of June 2026 in the chamber of the Deputy Commissioner Khifri on the matter relating to the seniority list of the Dobasi Khifri was discussed, including the claims and objections so submitted by the petitioners. And a decision in that regard was arrived at. So taking into account the above, nothing further remains in the instant writ petition, for which the writ petition stands closed as it had become infructuous. Before parting with the record, this court, however, observes that the closure of the instant writ petition shall not prejudice or prejudice the petitioners to challenge the seniority list as well as the minutes of the meeting dated 3/6/2026, if so otherwise advised, if so advised.
So I've already had the amended.
Yeah.
Orders, item number 15.
That is Lordship. Lordship, the petition.
What happened? Mediation? Anything?
Lordship, yes, though the mediation is failed, some steps were taken, Lordship. And my prayers were that, Lordship, my damaged properties were assessed and then reward made. Accordingly, verification was done, Lordship, and also assessment has been made, Lordship, and although the amount is less, we are also not disputing. So accordingly, this matter can be closed based on this report, Lordship. Verification was done on 20th March 2026. Then the assessment is from page number 7 to 9.
Your prayer is remaining, na, the award appropriate compensation.
Lordship, yes.
That remains.
Lordship, so based on this.
Understood. That is what they have to accept also, na. The government, the moment I direct, are you agreeable to make the payment as per the damage compensation? You will now say, oh, the payment has to be made by NHIDCL.
We are this Lordship. My Lord, I'm very one girl of putting things on the disseminate. And I've been instruction that matter will be was based on this.
Are you willing to make the payment of the compensation? My question is that.
Yes. The compensation will be paid by the NHIDCL.
There, the problem arises, madam. I pass a direction. Where is NHIDCL? Who is appears for NHIDCL? Where is Mr. Muajamil? And Mr. Sangtam here also, as I was saying, you have assessed the compensation. Now, once you assess the compensation, if they are satisfied with this compensation, then pass an award, consent award.
That's very poor by the.
Petitioner is only asking for assessment and making your payment. Now, if I direct making your payment and you don't pass an award, how will the land go to you? That is what I said on the last occasion also in that matter, where madam was again appearing. You need to, in view of this, you initiate as per 9.2,
Yes,
I showed you. Initiate the proposal, take over and then do it.
that should be her way.
That is her prayer, and then you get the money from NHIDCL. This is how it is. But if I close this by this and payment, tomorrow the state will have a big problem.
Yes. Proposal has to be sent.
Not only proposal has to be sent, you will also have to pass an award.
Yes, ma'am. After assessment.
Once the assessment has been done. So you have to now, on the base of the assessment, you have to send a proposal
Yes.
to NHIDCL. NHIDCL, on the basis of that, will make the payment to you. In the meantime, you take up the process of initiation as per Nagaland Land Requisition and Acquisition Act and take over under 9.2. Don't you think that if I pass an order, there is no problem for me in disposing of?
Yes.
That is a big problem which we are going to face.
Yes.
What do you say, Mr. Fong? You are paying for whom?
Anything is not additional agent. Still.
Where is he?
There is some difficult interview.
He has not come today.
Yes.
I can't accept that prayer, because if I accept that prayer and pass the direction, it will be a difficult thing tomorrow. And I am not going to pass that type of order. Yes, there has been an assessment being carried out. Madam, you bring it on record by filing an affidavit.
Okay.
And in the meantime, you take it up.
Yes, ma'am.
I'll observe that in the order.
Yes.
Heard Ms. So-and-so, the learned counsel, appearing on behalf of the petitioner. And where is Mr. Muajamir, NHIDCL? He was here now, very much here.
Yes, okay.
Can anybody go and ask him? Because in his presence, if we pass that order, it becomes better. Heard so-and-so, the learned counsel, appearing on behalf of the petitioner. Mr. E. Form appears on behalf of the respondent number 4, 5. And why do we require the private? They are not going to make up a single penny to you. This is not for damage compensation.
It is, Lordship. These are the damages done beyond our Lordship.
This is beyond our limit.
Yes, Lordship.
Or then there is no question of acquisition.
No, does not make sense.
But the payment has to be made by NHIDC.
Yes, through the recovered through the EPC contractor Lordship. That is the case.
And are they appearing? Who is appearing for the respondent number 6, 7, and 8?
Assessment was done in the presence of all the EPC contractors Lordship. With
Who are
NHIDC.
6, 7, 8?
Lordship, I for 8. Respondent 8.
And who is the contractor? Who is appearing for 6 and 7?
They are not here, Lordship.
Whether they are otherwise represented by lawyers?
Wait, Mr. Nagar, I've just contacted Mr. Noah over phone and we the case to one of the court.
Okay, very good. His name has not been shown in the cause list? And what is the item, other item, madam? You're 16, same?
No, it's different.
Different.
Yes.
We do one thing then. Heard Ms. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. E-form appears on behalf of the respondent number 4 and 5. None appears on behalf of the NHIDCL when the matter is called up. Ms. So-and-so appears on behalf of the respondent number 8. However, the respondent number 6 and 7 are not represented. The case of the petitioner herein is that the petitioners have been affected by the actions on the part of the private respondents, inasmuch as on account of carrying out the construction, the petitioners have suffered damages to their properties. It is under such circumstances the petitioners have sought for a direction upon the respondents to assess the damage, land and properties of the petitioners in presence and award appropriate compensation. It is seen that during the pendency of the incident, it is taken note of that the instant proceedings were sent for mediation so that a settlement could be arrived at. However, this court takes note of the mediation report dated 29/5/2026, wherein it is mentioned that the mediation proceedings were terminated as unsuccessful. Ms. N. Koza, the learned counsel appearing on behalf of the petitioners, however, submitted that in the meantime, verification was carried out as regards the damage compensation payable to the petitioners in presence of all the parties. And in that regard, have placed before this court a communication issued by the Additional Deputy Commissioner Futsara, Nagaland, to the Deputy Commissioner Pek, Nagaland, dated 3/6/2026. The said communication is kept on record and marked with the letter X. From a perusal of the said communication and the enclosures therewith, it is seen that the assessment of the properties affected for the project construction of the 2-lane road from Kohima Des Zesami under PWD H Futsera, section package Roman 2, Roman 3 and Roman 4 were carried out. And against 13 persons, a total compensation 14 persons,
15%.
15 against
Yes.
the 15 petitioner. All the petitioners are there, nah?
Except petition number 16, Lord.
Okay. Against 15 petitioners, the damage compensation have been ascertained, which is at page 6, 7, 8, 9, and 10, 11 of the said documents, of the said enclosure to the document kept on record and marked with the letter X. Now, this adjustment, this payment is to be made by whom? Because this is under the PWD. Why is NHIDCL involved?
What should be the similar case, Lord?
No, not similar case. This will be under the state. You will be asking what?
Yes, madam, I will read the case.
Don't appear then. Remove Mr. E-form's name. None appears for the state. Don't appear if you don't know. Mr. Sanktam, tell me one thing. If it is under PWD H Futsara section, it will be payment to be made by the state. Yes. But getting the money from Mort, NHIDCL has no business. They have made an NHIDCL unnecessarily a party. Because if I remember yesterday when I was taking up the other matter, the 2/2019 PIL, if you see, the road from Dimapur to Lerigate, they have put it, no, not to Lerigate, yes, Lerigate, they have put it, that belongs to the NHIDCL. From Lerigate to Jessama or something, Jotsoma, that area, Jasoma bypass, belongs to the state PWD, National Highway. State PWD, National Highway. And therefore the chief engineer appeared, state PWD. But there, the other portion, it is the authority engineer, NHIDC. You should have made proper parties. You should have made Morta party. Mort is there?
More is the lordship. It's one more.
Don't remove his name. Let his name be there. It is the opinion of this court that this very aspect be brought on record by filing an affidavit by the petitioner, so that appropriate directions for the purpose of payment of compensation can be passed. Ms. So-and-so, the learned counsel appearing on behalf of the petitioners, submit that such affidavit will be filed within 2 weeks.
Lordship.
List this matter again on 25th of June 2026. But Madam, I think the state PWD and Mort has to be there. They are there, Mort.
More is the lordship. It's one more.
NHIDCL, I don't think will have anything. Because it seems, it is said, categorically said under state PWD NH.
Yes.
So the state PWD NH has to be a party.
Yes. The same.
That is a necessary party. And then they will put the proposal to Mort and Mort will make the payment.
Yes.
Anyways, I've done my duty.
For orders, item number 60.
Yes, what is this?
This lawsuit, kindly allow me to explain the status of the case number in brief. My lord, upon representation submitted by the petitioner, the matter was forwarded to the EAC upon the jurisdiction of EAC. And we tried to settle the matter, however, the matter could not be settled. Thereby the EAC has written a letter to the matter is forwarded to the EC now. So accordingly, on 2nd June 2026, circular has been issued by the DC. Your Lordship, may kindly see the letter.
There's a stay,
Lordship.
but a stay.
There's a stake.
Who is appearing for that hell who have done it?
Lordship.
3 and 4, who is appearing? I don't think 1 and 2 is have passed that order.
No.
So it is 3 and 4. Who is appearing for 3 and 4?
Lordship, we have second step, Lordship, as I find in my compliance affidavit also, they refuse to accept notice, Lordship. Now, by way of speed post, notice classification again, you two should be registered, Lordship.
My lord, your Lordship, may kindly see the latest status of the case.
Okay, additional affidavit, the affidavit of compliance has been filed. So we do one thing, let us see whether the service is complete or not. Who received it? Okay. In pursuance to the order dated 29/5/2026, the registry has placed before this court the affidavit of service so filed by the petitioner, insofar as affecting service upon the respond number 3 and 4. At paragraph number 3, it is categorically mentioned that though an attempt was made to serve it upon the respondent number 3 and 4 on 24/2026, but they refused to accept the notice and also further refused to acknowledge the same. Considering the above, the service upon the respondent number 4, 3, considering the said affidavit of service, this court deems that the service upon the respondent number 3 and 4 to be complete. List this matter again on
Please, Lordship. Lordship, can you see the letters? Status of the case below.
what is
The
that?
DC has issued release circular on 2nd June 2026, inviting all the parties to settle the matter now. And the matter is fixed on 10 June 2026. So my lord,
List the matter. When is the next date?
10 June.
List this matter again on 23rd of June 2026 for admission.
Yes.
This court also takes note of the communication issued by the Deputy Commissioner, Mokok Chong, to all the parties for a meeting on 10th of June 2026 in his office so that the matter could be amicably resolved. In that regard, the meeting circular have been placed by Mr. E. Form appearing on behalf of the respondent numbers 1 and 2. The same are kept on record and marked with the letter X. Under such circumstances, the respondent number 2 shall apprise this court on the next date as regards the outcome of the said meeting. Interim order passed earlier shall continue till the next date.
Alright,
Orders, item number 1751.
What is this IA for? Yes.
As the problem.
Huh?
For the people in the reflection as a responsible.
You want to be implemented?
Yes, I know.
Who are do?
Well, this is the few order the reflection at stage 12 now.
Page 12 of the writ petition.
Of this application.
Application page 12. Yes.
Page 12. This is the order which has been taken over the petition. And no interest is involved.
Okay. You are not objecting.
Was it just 5 minutes? I have filed my affidavit of opposition.
That we permit just for the sake of it. We recorded that you have objected. And we further put another adjective out there strenuously. But we are going to allow it. Okay. Madam, I think all these matters you have filed.
Yes. Until 27.
Okay. There will be a separate order. I'll dictate only one. You make the others same. Others will be same orders. Heard Mr. Im Chong, the learned counsel appearing on behalf of the petitioner, applicant. Tim Langjang, the learned counsel appearing on behalf of the applicant. Mr. T.B. Jamid, the learned counsel who appears on behalf of the opposite party, number 1, who is the writ petitioner in the accompanying writ petition. Mr. L.T. Sangtam, the learned additional advocate general, Nagaland appears for the respondent number 2 and 3. Opposite party number 2 and 3. Performer opposite party number 2 and 3. What about the others? No. Okay.
Suppose you can proceed the main petition also not there, not entered there, during those reviews.
It's okay. We will pass that order in that meaning. This is an application filed by the applicant seeking appropriate directions that application filed by the applicant saying that seeking directions that the applicant be arrayed as a party respondent to the accompanying writ petition. This court have duly taken note of the decision, the cause of action for which the writ petition has been filed, whereby the order dated, Mr. MT, in all these cases, the same date order 6/11 in all the cases. That the order dated 6/11/2023 have been assailed. This court also takes note of that the order impugned in the writ petition, which is 6/11/2023, confers certain rights upon the applicant. And under such circumstances, it is the claim of the applicant that the applicant is a necessary party for the present adjudication to be made in the writ petition. Mr. T.B. Jamid, the learned counsel appearing on behalf of the opposite party number 1, who is the writ petitioner in the accompanying writ petition, opposes to the said application on the ground that the petition applicant is neither a necessary party nor a proper party for the purpose of adjudication of the accompanying writ petition. He further submitted that an affidavit has also been filed objecting to the present application. This court have also duly perused the said affidavit. First, upon perusal of the impugned order impugned in the writ petition that is dated 6/11/2023, passed by the Office of the Deputy Commissioner, Dimapur, it is seen that the rights of the applicant have also been taken note of. And it is the opinion of this court that any adjudication made to the in the accompanying writ petition where the order accompanying writ petition without hearing the applicant would not be in the interest of justice. It is the further opinion of this court that applicant herein is a necessary party to the accompanying writ petition. Accordingly, this court impledes the applicant to the accompanying writ petition as the respondent number 10. Full stop. The counsel appearing on behalf of the petitioner, writ petitioner, is directed to file a fresh memo of parties before the registry of this court within 7 days, and the registry on the basis thereof make necessary changes in the cause title of the accompanying writ petition, as well as update the same in the CIS. IS stands disposed. Now in the main writ petition you write, Mr. Imti Longchet, the learned counsel appearing on behalf of the newly impleaded respondent number 10, submits that he is already in possession of a copy of the writ petition. He, however, submits that the respondent number 10 would like to file an affidavit in opposition. Taking into account the above, list this matter again on 27/2026. In the meantime, the respondent number 10, have the others filed affidavit? No.
No.
In the meantime, the respondent number 10 as well as the state respondents, state has filed. The respondent number 10 as well as in the meantime, liberty granted to all the respondents, including the respondent number 10, to bring on record their stand by filing the affidavit on or before 17th of July 2026. This order will be there in all other cases, similar orders. Huh?
20, your worship, this petition potential of 2025, I can go 80. The petition 43. In this case, what has happened about this? During the pregnancy of the petition has expired. He was substituted by his son, and she was substituted his son.
You have substituted.
Yeah, and the son has taken steps. For making service upon the other respondent, and the worship affidavit also have been filed. Affidavit of service justice that is the worship affidavit filed on 20/14/2026.
Madam, in this item 20, in addition to that, what has been mentioned, I've already, that you put it in that case also. What I have put it, he wants to file affidavit, everybody wants. Then below that, only in this case. This court have also taken note of the affidavit of service which have been filed by the petitioner on 24/2026. Pursuant to the order passed by this court on 12/3/2026. From a perusal of the said affidavit, it is seen
Paragraph 3, your worship, respondent number 3 has declined to accept notice. So I have received to
the respondent number 3 have declined to accept, have refused to accept service, whereas the respondent number 4, 5, 6, 7, 8, and 9 have duly accepted the notice. This court also takes note of the affidavit, the annexures to the said affidavit of service, and taking into account the above, this court deems that the service upon the respondent numbers 3, 4, 5, 6, 7, 8, and 9 are complete.
From the supplementary cost list for orders, item numbers 24 and 25.
Yes, we allow this. There is an application filed by the legal heirs of the respondents, or legal heirs of the legal heirs of one Joydeep Datta, who was the petitioner, who had expired on 12/1/2026. It is also taken note of that this court, by this order dated where is the other order? There's another IA, no? Dispose of IA is there?
29 is this one.
By an order dated 29/5/2026, passed in IA Civil number 81/2026, arising out of WPC number 135/2025, had granted leave to the applicants to file a leave of the applicants to file a separate application for the purpose of the instant writ petition. Taking into account that the right to proceed, right to sue survives, right to not proceed, right to sue survives upon the legal representatives of the original petitioner upon his death. This court substitutes the original petitioner of the present application with his legal heirs, whose names have been mentioned at paragraph number 4 of the instant application. The legal heirs of the original petitioner is hereinafter is arrayed as petitioner number 1.1 and 1.2 to the accompanying writ petition. The counsel appearing on behalf of the petitioner shall, within 7 days from today, submit a fresh memo of parties before the registry of this court, and the registry shall, on the basis of the present order, as well as the said memo of parties, make necessary changes in the cause title of the accompanying writ petition, that is WPC number 136/2025, isn't it?
Yes, Lord.
25. And update the same in the CIS. I stands disposed. Put his name, huh? He appears for respond number
3 and 4.
For hearing, item number 23.
What is this matter about?
This is on language case. Which is the opinion of respondent to the respondent.
You are a landowner.
Yes, ma'am.
That is okay. But private respondent has been appointed without legal process.
Yes. Without the legal process. And
Is
that
it-
against the vacancy was
Mr.
like.
Takakichu? No legal process. And help it. We can't allow him to be appointed, but we have to interfere with your appointment. He has a right. He has one right of in view of the land policy, and the other is the right pertaining to an equal treatment under Article 14 and 16. That is the difficulty. Hearing complete? Let me deliver the judgment now. Hearing complete, judgment I can now dictate. Yes, yes. I will grant you age relaxation.
No, my lord, but I am the landowner.
Understood. The landowner is not specific to a particular job. It is specific to a post.
Yes, but
Where?
there is an agreement.
Maybe you have a right to be appointed against the post. Or you have a right to be appointed against the land ownership.
Yes.
But do you have a right to be appointed against that particular job?
No, but that was against the land where I was donated.
Understood, but that can I say that? Can I say that this is to that post? I cannot say that. I may very well say that the state may considering your case for land ownership, or may go for a fresh advertisement for the purpose of selecting anybody. That I can say.
If the direction.
You show, Mr. Counsel, you show me that can the appointment on land ownership be against a particular post?
Yes, if there's an agreement.
It can only be, it's a right conferred.
Yes.
They may do so. Just for example, there are 10 MTS posts. Can you say that to pinpoint this post against this, kindly give me land ownership? That is what I'm saying.
It's only one.
You have a right to be considered for appointment.
Yes.
But I can't say on the
Yes.
basis of days.
Yes, but if the direction is that if.
You will be considered.
Yes.
And the state may also, if the state feels like they may do so by way of going for a selection process. But we cannot allow that it has to be pinpoint to that, because I don't have the jurisdiction for it. What do you say, madam?
Again, this is the second round of litigation. And then here, the government has already given the assurance that as and when the next vacancy arises, my case will be considered.
So the vacancy, then they will consider, yes.
Lordship, this for implemented,
Election
there
fees.
by 1978, cited by the 13 land owners. The area of 50 acres of land was donated. However, Lordship, the department has realized only 29 more than 3 acres of land.
Huh?
Land owners have donated 50 acres of land. However, the department has utilized only 29.93 acres of land. So out of 13 land owners, only 8 land owners were retrieved. So the petitioner, including the petitioners, the department has not utilized his land. So the petitioner has no value.
Madam, I'm not on that.
Okay.
I'm not saying that whether he's entitled or not, that will be subject to the recommendation made under 3B. As per 5/3/2018 notification, it is the Deputy Commissioner who has to make a recommendation. The Deputy Commissioner will look into it as to whether he is entitled or not. I'm not here to decide that he is entitled to. No. I'm not also there, but this appointment of the respondent cannot be there on the ground that he was appointed without following a due process. So we set aside. But while doing so, as he has worked all this while, we have to also give an age relaxation. If you go for an advertisement, provide an age. Isn't it, Mr. Takakisu? It is true.
Well, I will be
Now,
taking the name. Page 43. Yes, the assurance.
page 43.
Page 43.
Yes.
That book is a page from the next page.
Let us read 43. I am directed to refer to your letter and hereby confirm that so-and-so was appointed based on senior-most contingency employee, and once appointed by the government cannot be terminated or superseded. Moreover, he is also one of the landowners. Hence, the complainant case may be informed that his case shall be considered when vacancy arises. So very well. This is being given by the Undersecretary Sericulture Department.
Yes.
Very well, they will consider your case.
Yes.
But I am not the Deputy Commissioner. So we need to finish it off by 1 o'clock. Judgment. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Miss So-and-so appears on behalf of the respondent numbers 1, 2, and 3. Mr. Takakichu appears on behalf of the respondent number 4. Madam, you are expert in land ownership. Huh? Okay. The petitioner herein is aggrieved by the appointment of the respondent number 4 to the post of what? Post?
Yes, on taxes from.
To the post of MTS. To the post of peon bracket MTS in the district sericulture office Khifri, and accordingly have challenged the approval letter dated 6/2/2024 as well as the appointment letter dated 12/2/2024 to the in favor of the respondent number 4. The case of the petitioner is twofold. First, that the petitioner ought to have been considered for appointment as on a land ownership basis in terms with the notification of the government dated 15/3/2008, 5/3/2018, as well as the appointment of the respondent number 4 was carried out without calling for an advertisement and as such violated the mandate of Article 14 and 16 of the Constitution. First, the brief facts which leads to the filing of the present writ petition are that the petitioner that the Oak Tassar firm, I don't even get the name at paragraph 5, Oak Tassar firm, Helungri village under the district sericulture office Khifre was established as per the claim of the petitioner upon a land donated by 13 landowners, which includes the father, grandfather, which includes the grandfather of the petitioner. It is the further case of the petitioner that a written agreement was entered into on 10/5/1978 between the 13 landowners and the state government, wherein it was agreed in principle and in good faith that in lieu of donated land, preference should be given to the landowners for appointment to grade 4 posts arising in and against the said firm. The petitioner herein, who is the grandson of the late Mulingmong, who was a signatory of the said agreement, claims that the petitioner's family have not availed any post, any job in lieu of the donated land. It is the further case of the petitioner that a post of peon cum chokidar MTS fell vacant at Oak Tassar firm, Pelinguri village under the district sericulture office Khifri, when Sri K. Thongkochu Sangtam had applied for appointment on land ownership basis. In support of the candidature of the petitioner, the petitioner thereupon submitted an application. It is a further case of the petitioner that the said Sri K. Thongkochu Sangtam was released from service on 30/9/2023. Under such circumstances, the petitioner submitted an application claiming appointment on land ownership basis. It is the further case of the petitioner that not only that the director of the undersecretary to the government of Nagaland Sericulture Department had also stated, had also categorically informed the director of sericulture that what is this document? How is this have relevance with you? Page 43.
My lord, against the liberalization of the from Tokyo, which is the party of the Resolution number 4, we have the landowners, the landowners of my grandfather's. We have submitted a complaint against this liberalization because earlier also the case was considered. But here, in response to our complaint, the letter of turnover was issued that
So that post became vacant.
yes,
So against that you are applying.
yes,
Did you submit an application?
yes,
When?
complaint.
No. Did you submit an application for appointment on land ownership basis?
Yes,
Where is that?
annexure C,
Annexer?
C, page 97.
Okay. And against the release of Sri K. Thangpochuk Sangtang, and in view of the vacancy arising, the petitioner submitted an application on no date. Had submitted an application for the post of peon cum chokidar at Oak Tasar Farm, Pelungri, Pusto. To the surprise of the petitioner, that the petitioner's case was not considered in terms with the notification dated 5/3/2018. Rather, the respondent number 4, who was the son of Sri K. Thongkochuk Sangtam, was appointed to the said post, that too without carrying out any process as mandated under law. It is under such circumstances the petitioner has approached this court challenging the appointment of the respondent number 4. And further seeking directions upon the state to appoint the petitioner to the post of peon MTS District Sericulture Office Khifri on land ownership basis. The records reveal that the respondent number 1 to 6, respondent number who is this, madam? Subject is there. Who has filed this? Who is the director is what is the respondent? Huh? Director is what is the respondent? Even this is the last item? Yes. Okay, let me finish it. Last, this. Huh? The respondent number 3 has filed an affidavit in opposition. Wherein the execution of the agreement dated 10/5/1978 was duly admitted. And also admitted that the petitioner's grandfather was a signatory to the said agreement. It was also mentioned that all civil works for construction and repairing were done by the landowners. In addition to that, it is also mentioned that in respect to the land which was donated by the petitioner's grandfather, no employment was granted, as their land was not required for the establishment of the firm at Pelunguri village, Kifre. It was further mentioned that there were total numbers of 7 MTS vacancies in various district establishments of the Directorate of Sericulture. The DRB was held for all the 7 vacancies. However, 6 vacancies were processed jointly and 1 vacancy was processed separately. All the 7 numbers of posts have been filled up as per a meeting minutes of the DRB held on 20/12/2023. And the remaining 1 post was also forwarded on 16/1/2023 and recommended on the same DRB meeting dated 20/12/2023. Further to that, it is mentioned that by the order dated 15/12/2023, Sri Shikhan Bimbo Homestay was, there is a response number 4, na? Who is it? Shikhan Bimbo Homestay was appointed as the MTS. Huh? Was appointed as MTS under the establishment of District Sericulture Office. This court have further taken note of the said affidavit. And there is no mention that the appointment of the respondent number 4 was preceded by any advertisement. The respondent number 4 has also filed an affidavit in opposition, wherein various facts have been mentioned and have relied on a copy of the office memorandum dated 3/3/2022, wherein the government of Nagaland have dispensed with the advertisement in terms with for Group D post, isn't it? This court have duly heard the learned counsels appearing on behalf of the parties and have duly perused the materials on record. The petitioner's claim, as stated herein above, are twofold. One, that the petitioner is entitled to be considered for appointment in terms with the office memorandum, the notification dated 5/3/2018. And secondly, the post which was filled up by the respondent number 4 could not have been done without following a process by which inviting without calling for any advertisement. Insofar as the appointment of the respondent number 4 on land ownership, there are factors which requires to be taken into consideration, which have been mentioned in the notification dated 5/3/2018. Clause 3A of the said notification refers to written agreements. First, and the procedure to be followed in respect to the claim of the landowner for employment. Taking into account that there is no denial to the agreement dated 10/5/1978 that the grandfather of the petitioner was one of the landowners. The question therefore would arise that the question would therefore arise with the of the landowner. The petitioner herein is therefore ought to have been considered in terms of the notification dated 5/3/2018. This court also cannot turn a blind eye to the fact, to the statements made at paragraph number 4 by the director of the Department of Sericulture, to the effect that though the land was donated, but the land which was donated by the petitioner's grandfather was not taken by the Department of Sericulture. Isn't it, madam?
It's not like still under property. Not-
Understood. It is not taken by the sericulture. The question, however, arises as to whether after the donation, the sericulture department have returned the land back to the petitioner's family. This is an assessment which is required to be done by the sericulture department of the government of Nagaland. While considering as to whether the petitioner's case comes within the notification dated 5/3/2018. Next. The second aspect, which is clearly envisaged, is apparently seen, is that the second aspect of the matter pertains to appointment of the respondent number 4 without following a due process. That is by issuance of an advertisement. Though Mr. Takakishu, the learned counsel appearing on behalf of the respondents, number 4 emphasizes on the office memorandum dated 3/3/2022. But in the opinion of this court, the said office memorandum cannot override the mandate of Article 14 and 16 of the Constitution, whereby advertisement has been held by the Supreme Court to be one of the basic facets for appointment into public service. Accordingly, in that view of the matter, it is for the opinion of this court that the respondent number 4's appointment without calling for an advertisement is in violation to Article 14 and 16 of the Constitution. This court also duly takes note of the submission of Mr. Takakishu, the learned counsel appearing on behalf of the respondent number 4, that the respondent number 4, since his appointment, there was no stay. Since his appointment have been rendering service from the year 2024. And in the circumstance that the appointment of the respondent number 4 is set aside on account of the respondent number 4 in view of the permissible age limits, the age, on account of the age, may not be able to compete in the circumstance. Age, problem? No problem. No, you have a problem. You don't have a problem. Okay, that you remove it. Taking into account the above, this court therefore disposes of the instant petition with the following observations and directions. The impugned government approval dated 6/2/2024, insofar as approving the appointment of the respondent number 4 is set aside and quashed. Number 2, the impugned appointment order dated 12/2/2024, insofar as the respondent number 4 is concerned, is set aside and quashed. First, the respondent authorities herein, and more particularly the respondent numbers 2 and 3, shall take a decision as to whether to retain the land which the grandfather of the petitioner have donated, or to grant appointment in terms with, provide appointment in terms with the notification dated 5/3/2018. In the circumstance, the respondents number 2 and 3 duly take the decision to retain the land which was donated by the grandfather of the petitioner. The petitioner have a right to claim to be considered in terms with the notification dated 5/3/2018. Accordingly, the respondent numbers 2 and 3 are therefore directed to consider the case of the petitioner in that light. Number 4. This court further observes that a claim to be appointment on land ownership basis cannot be against a specific post. It is a right, it's a right to be appointed on the land ownership basis. And as such, it shall be, and as such, it's only a right to be appointed again on the basis of the policy of the government on land ownership basis. Under such circumstances, this court grants the liberty to the state to take a decision to the respondent number 2 and 3 to take a decision as to whether the said respondents would like to proceed, respondent number 2 and 3 to either fill up the vacant posts of so and so MTS at where? District Sericulture Office, Kifri. Either in terms with the notification dated 5/3/2018 or by way of an open advertisement. Huh?
If I be allowed to make one submission, Lordship, may kindly come to agreement bench 26. What is the type of the objective?
Yes, what is that?
26 of the repetition, Lordship.
Huh?
Bench 26 of the repetition. Point number 3, Lordship. If I may be allowed to read.
Yes.
If the Department of Industry fails to commissions and run the project, the land shall go back to the landowners. And the right of positions and the disposal of the common properties only shall continue based with the common Lordship. It is
Where?
page 36 of the repetition.
If the department fails to commission and run the project, the land shall go back to the owner and the rights of possession and disposal shall continue to vest with the government. And the rights of possession and disposal of government properties only shall continue to vest. What do you mean by that?
Lordship, sir, the department is not utilized of the petitioner name.
No, therefore I have given you the liberty either to retain the land or if you are holding it. If you are not holding it, the land, give it back. But you cannot usurp the land on one hand and not grant a land ownership, or not apply the 5/3/2018 if he is entitled to. That's the simple thing.
Since 1978, we have been waiting for this.
Huh?
Since 1978, after this agreement, we have been waiting for action.
Your son may get it.
And then after
Okay, but the last one? I shall go for an open-ended advertisement. Pustu. And what else, Mr. Tagaguchi? What order can I pass? Nothing. You have the age. You filed the affidavit in 2024. 25. 25, na? Huh? 25 to 1 year, 33 now. You have the age till 35, na? Without, there shall be no order as to cost.
Thank you very much.
I don't know.